Good evening. I'd like to bring this meeting to order, and we're going to convene into a public meeting to deal with a couple zoning bylaw amendments, and with that, I'll read a resolution to do so. Be it resolved, the Council of the Township of Whitewater Region convene into a public meeting in connection with one zoning bylaw amendment. Zoning bylaw amendment, Part Lot 15, Concession 3, Ross, 1089 Olmsted, Jeffrey Lake Road, Inglis. 2, zoning bylaw amendment, Part Lot 4, Concession A, CLF, Westmeath, Yakabuski Road, and Cad's Trail, Cadsbrook Farms Limited. With that, all those in favor? Carried. And with that, we're in public, and I will give it to Christine to discuss.
Thank you, Mr. Chair. I'll read the zoning report, the summary of the zoning bylaw amendment. This zoning bylaw amendment pertains to the subject lands Ross Concession 3, part of Lot 15, located at 1089 Olmsted, Jeffrey Lake Road. The purpose is to rezone a portion of a 0.16 hectare residential waterfront property with an existing dwelling to permit a new detached garage. The owners are requesting permission to construct the garage within the front yard of the lot. Section 3.3B of Zoning Bylaw 23-92 of the former Township of Ross prohibits accessory buildings in any front yard. The garage will also require a reduction in the minimum front yard depth of the rural zone from 7.5 meters to 4.5 meters. A portion of the lot is zoned Environmental Protection, EP, which is not affected by this application. The effect of the amendment is to rezone a portion of the subject property from rural, RU, to rural exception 36, RUE 36. If a person or public body does not make an oral submission at this public meeting or make a written submission before the bylaw is passed, they are not entitled to appeal the township's decision to the Ontario Municipal Board, nor may they be added as a party to the hearing of an appeal before the OMB unless the board agrees there are reasonable grounds to do so.
Okay, we would ask now for anybody who has public comment in regard to this issue. See none. Questions from council? Concerns, questions? Councillor Olmsted?
Yeah, we're just looking for our building officials' comments on it.
Good evening, or good afternoon, I guess, yet. I don't see any problem with this zoning amendment. The road is far enough away from this, and there's a bank there. The reason the zoning amendment is required is because in the old Ross zoning bylaw doesn't allow accessory buildings in the front yard. So that's why we're requiring a zoning amendment. If that wasn't in there, we could have did it with a minor variance. So I don't have any problems with this one.
Oh, that, yeah. Go ahead, Councillor Olmsted.
So we haven't received any type of response from neighbors, or?
We have not received any objection.
Any further comments? Okay. We will pass the bylaw in our regular meeting a little later on. Now, Christine will speak to the second report.
So the second zoning matter in this public meeting, this zoning bylaw amendment pertains to the subject lands Ross Concession 3, part of Lot 15, oh, I'm sorry, I'm reading the wrong one. I just read that. This zoning bylaw amendment pertains to the subject lands Westmeath Concession A, CLF, part of Lot 4, located on Yakabuski Road and Cad's Trail. The purpose of the zoning amendment is to rezone approximately 10.9 hectares of a 74-hectare waterfront property that is owned and operated under a family corporation Approximately 7 hectares of the property currently contain 11 legal, non-conforming, single detached dwellings that are leased on a short-term basis to family members only for seasonal or year-round occupancy. An additional 3.9 hectares is proposed to be developed with 8 new single detached dwellings for the same purpose. All of the dwellings are accessed by a private road called Cad's Trail. Currently, the zoning bylaw permits only 1 dwelling per lot. The proposed amendment would allow more than 1 dwelling per lot on a property owned and operated by a family corporation and would place the existing and proposed dwellings in a holding symbol. Specific conditions will be required to be met to council satisfaction before the holding symbol is removed by bylaw, and changes to the existing buildings or new development can occur. Conditions would include an approved site plan and agreement, hydrogeological studies with nitrate impact assessment, Ministry of Environment and Climate Change Environmental Compliance Approval, ECA, agreement for private road standards and maintenance, and an archaeological assessment. The effect of the amendment is to rezone the 7 hectares containing the existing dwellings from waterfront vicinity, WV, to waterfront vicinity exception 44 holding, WVE 44H, and the 3.9 hectares for the purpose of new dwellings from waterfront vicinity to waterfront vicinity exception 45 holding, WVE 45H. Removal of the holding symbol will require a bylaw of council when it is satisfied that the above noted conditions have been met. If a person or public body does not make an oral submission at this public meeting or make a written submission before the bylaw is passed, they are not entitled to appeal the township's decision to the Ontario Municipal Board, nor may they be added as a party to the hearing of an appeal before the OMB unless the board agrees there are reasonable grounds to do so.
Thank you, Christine. Anybody from the public have a comment in regard to this issue? Seeing none, council, how about our building inspector to speak on it now?
Yes, this is a very unique situation where a family has had this property for years and has developed it, and now they want to enlarge it by adding more cottages on it. We've been told by the county to hold it in abeyance yet, not make a decision yet tonight, because there's a few outstanding issues that we are working on that we are very confident that can be worked out, and that once they're worked out, it will come back to a meeting.
Thank you, Doug. Any further comments? Councillor Olmsted.
Is a legal non-conforming single detached dwelling, is that the definition of a cottage?
That would be the definition of a cottage, but there's some permanent places there also on the property. So we're saying legal non-conforming single detached dwelling, that's the same as the house actually.
Okay, so another 8 would be, I think it was 8 are going to be built. Are they going to be legal non-conforming?
They will be put in as a holding symbol in that area, and that'll be only allowed with that site plan to be done. There is, I think, 188 acres in this property, roughly, so it's a pretty large piece of property, Chris, and they maintain it all themselves. They may look after the road themselves. So instead of going through the subdivision purpose, it was decided to do it this way.
Thank you.
Thank you. Any further comments? Councillor McLaughlin, please.
Maybe this would go to Doug, so that if any of those dwellings were to be removed from, or go to a second person, like non-family, then there would have to be a lot of work done before that could possibly happen.
I think that it's a family corporation, and I think that is in the agreements that only family members can own it.
Okay, no, that's one of my main concerns. As long as it's going to stay within the family, I would have no concerns with it.
Any further? Yes, sir? You'll have to come up to the table and the mic, please, sir. And what's your name, sir? Tommy Dunfield.
Thank you. Just on this gentleman's comment, I'm a part owner, and I'm one of the full-time residents of the property. It's been in the family for 54 years, or sorry, 62 years. It was bought in 1954. So the corporation was formed essentially to keep the property as a whole, and to allow only family members, i.e. the descendants of the original owners, to build and use it as a recreational property. We also manage the forest, and we have some wetlands, conservation land that we set aside for conservation. So we don't see any possibility of it ever getting severed or ever getting divided. The whole purpose of our what is basically a very unique application, we think, for this township is to keep the property as one, and for the one family to enjoy in the future generations.
Yeah,
Councilor McLaughlin?
and that was my main concern, as long as it was going to stay within the family, because the problems that exist after it
Right.
gets moved out. And that was where my comment was coming, so
Yeah.
you've basically addressed it. And
It's a good point. We've been through a number of divorces within family members. We're into the fourth generation now, so we've been around for a long time. We've had no problem with those separations. And our main objective, we have some 20 shareholders in the company who are all part of the dwellings and the leases that we allow for the dwellings. Worst case scenario, if we ever had any ownership problems or severances, we have to get the majority, actually 76% of the preferred shareholders and the majority of the board of directors to permit any kind of ownership change. We've been going for 62 years. We don't see any problem in the future with this. It's going to be held as one. It was bought that way, and that's the way we want to keep it.
Thank you. Any further comments?
Thank you.
Thank you. Okay, seeing none, we'll leave that issue to Doug for county to comment on. That's how we're leaving it. Close the meeting. And we're going to have a resolution to close the public meeting. Be it resolved that the public meeting of the Council of the Township of Whitewater Region be adjourned at 6:14 p.m. All those in favor? It is carried. I need a new pen.
Here.